Did you know that Washington State has the highest estate tax in the nation, tied with Hawaii at 20%? Um, my name is Scott Caulfield. I'm with Sophos Wealth Management. Just wanted to give some tips on how to reduce that estate tax if you're here in Washington, or eliminate it, and just cover some quick estate planning basics for you today. So I think most people are familiar with, last will and testament. That's your chance to, create that legally binding document that gives the person's, final instructions for how their money, property, and other assets should be handled after their death. It's that wills, well, if you have minor children, that's a good place to, list your wish for their guardian. But that will is also a good opportunity to identify all your assets and debts for your beneficiaries. So what are your investment account numbers? Where do you have life insurance? Where's that at? Any other things? Where's your bank accounts? What are all those numbers? All that kind of stuff, so that people don't have to dig through your mail that much. And it's also just so much easier when you've laid everything out for the beneficiaries, avoiding confusion. And then, the other big part of estate planning is trying to kind of avoid some of the other headaches, like probate. So, probate's the legal process that occurs after a person dies. So, it's through the courts. Your assets are identified, your debts and estate taxes are paid, fees for lawyers, appraisers, court filings, all that kind of stuff's handled there. But that probate process in Washington, I think, takes 6 to 12 months on average. 4 months is the shortest it can take, because that's the time needed to give creditors a chance to make a claim against your estate. Investing markets are dynamic, so a lot can happen in 6 months to 12 months in the stock market, and your beneficiaries might have drastically different investing ideals or proper asset allocations than maybe you had the assets. So it's just so much better to get those passed on more quickly, and things like that. It's not that difficult to do. So take investing accounts, you just have to designate those beneficiaries. So on your IRAs or your individual accounts or 401ks and things like that, it's pretty simple to just make sure that you've got your that you designate your beneficiaries there. For things like checking accounts, savings accounts, you can make those pay on death designation accounts. So the same thing, they'll pass, they just need a death certificate, and they'll pass through without the probate process. And then, a little bit more complicated on some other property, let's say like your house, or if you have like rentals, generally people set up a living trust, which they have control over, but then they will retitle the property, so say your house, in the name of the trust. So the trust owns it, but you're in control of the trust. And then upon passing, the trust has its instructions on what to do or who to give that property to. So again, that's a way you can get things like your house outside of the probate system. That won't work for things like most automobiles, just because, car insurance companies, they don't want to insure a trust, they want to insure a person, but it gets most of your big assets outside of the system. And then for those who own small businesses, then it gets, a fair deal more complex with some of what their planning needs are, but that's probably for a different day. So getting into Washington State's estate tax, we've got an exclusion amount of just under 2.2 million. So it's 2,193,000. So that's the amount of your estate that is not subject to taxes. So if a married couple does it properly, it's just under 4.4 million. But to do things properly, they generally need to set up what's called a credit shelter trust, also known as like an AB trust or a bypass trust, a few other names. And that even can just be put in your will to do that. But to give you an example, if you have a married couple with a $5 million estate, scenario A, they don't set up the credit shelter trust. So first spouse passes, the surviving spouse gets all the assets, passes away, and that $5 million estate goes to their beneficiaries, but they only get one exemption then. They lose the first ones. There's no what they call portability of exemption in Washington. And so that $5 million estate receives a $2.2 million exemption. That means it's a $2.8 million taxable estate left. they end up paying like $360,000 in estate taxes before their beneficiaries get the rest of the estate. That same couple, if they were to do the estate planning, set up that credit shelter trust, when the first spouse passes, their half the assets go into the credit shelter trust, or the amount up to the 2.2 million exemption. So the surviving spouse still, has access to income and things from those assets, but then upon passing, that $5 million estate receives essentially 4.4 million in exemptions or exclusions. So that only leaves a $600,000 estate. That results in like 60,000 in estate taxes. So the first estate, scenario A, they paid 360 grand. Scenario B, they paid about 60 grand. That's about a $300,000 difference. So, in Washington, it's not hard to get above that exclusion amount of 2.2 million. For retirees who have some investable assets, for those with life insurance, and look at what property prices around the greater Seattle area have done, and the whole state. But it's not inconceivable if you own a home in Seattle and you've got some investing assets, you need to do some planning here. At the federal level, the estate, that exemption amount is portable, and it's a much higher exemption amount. It's 11.7 million in 2021. And so for a married couple, that's over 23 million. And the other thing about the federal one is, it's going to change in 2025. So there may be some additional planning there, but most estates aren't subject to that, just being under 23 million. And then, for portability, the federal one, all you have to do is file this Form 706 estate tax return with the IRS upon the first spouse's passing. So it's maybe a little bit less complicated, but those with estates that are subject to that generally have some good planning and estate attorneys anyway. So some of the other things, just I think to keep in mind for other considerations with estate planning. There's something called like a living will, or also known as like directive to physicians or healthcare declaration. That's just where you kind of state your wishes about life support or other kind of medical treatments. A lot of people will list like a power of attorney. So that's where you name somebody to handle your financial matters or medical decisions in the case you become incapacitated. And then, with estate planning, there's just lots of, emotionally charged decisions and nuances where it can get more complex. I mean, when you look at family heirlooms, who gets grandma's china, things like that. And, there's lots of resources out there for things like that. But, obviously just, I think, having communication with the future generation. And then, there's also difficulties, look at like somebody's got kids from a prior marriage, and setting up the trust and beneficiaries in such a way that they make sure everyone's taken care of according to their wishes. And there's those who maybe don't trust their beneficiaries with large sums of money. So again, there's planning opportunities around things like that. But I think the big thing for those in Washington is it's the highest estate tax out there. So it's worth doing some planning, looking at where you're at or where you could be at if your assets continue to grow over the next few years, and get out in front of that. So if you have any questions, give me a call or email. And for more information, go check out the blog at sophoswm.com, where I kind of lay out some of this stuff. So thanks for listening.